Everyone, welcome to Office Hours. Today, first off, well, thank you to our sponsors, Hemmat Law. Go to gossip.prejudice.com if you want to learn more about us and our mission. Also go to hemmatlaw.com/GWP if you need a good attorney or want to join an amazing team. We're doing something a little bit different today. We are doing a metaphorical power hour of LTBE. We're doing Lindsay takes the bar exam. Where we have Lindsay take the bar exam without any legal knowledge. But we're going to be doing, instead of questions this week, we're doing extra bar exam questions, and we're going to be trying that out for a couple extra weeks just to see how it goes down.
Yeah.
Lindsay, how you feeling today?
I'm experiencing questions and thoughts about what my record will be of these next few weeks. What am I going to get right? What am I not going to get right? But you know what? Even if I get it wrong, maybe I sound like a little bit of an idiot, but it's so much fun. It's really interesting to peruse these questions and really give it my all. And
yes.
maybe you're learning something too, which would be great. So shall we?
Let's jump right into it.
Let's do it.
Are you ready for your first question?
I'm ready.
So we are doing an evidence question.
I'm ready.
All right, here we go. On cross-examination, a lawyer asked a character witness, quote, "Isn't it true that you told your neighbor that you were a licensed real estate agent?" The opposing party objected on the grounds that the question called for hearsay. The judge overruled the objection. Which of the following findings would most support the judge's ruling?
Oh. Okay. I don't know where to start. I don't know what hearsay means. I know that years and years ago, what it feels like, just a few months ago, we were here with Paige, and we were talking about how there's so many exceptions to hearsay, and I don't really know anything about that. So what are my answer options, please?
Answer options are A, the character witness's answer was not being offered to show that she was a licensed real estate agent. B, the character witness's answer was not relevant to the underlying cause of action. C, the character witness was available for redirect examination. And D, the rule against hearsay does not apply to character witness testimony.
Ooh, I have no clue, folks. Would you read me the question one more time, please?
On cross-examination, a lawyer asked a character witness, "Isn't it true that you told your neighbor you were a licensed real estate agent?" The opposing party objected on the grounds that the question called for hearsay. The judge overruled the objection. Which of the following findings would most support the judge's ruling?
What was answer C again? That one stuck out to me.
Answer C, the character witness was available for redirect examination.
I don't know what that means, but I like the sound of it because the question is probably pertinent, but we don't know what the case is. So we can't say yes or no, this is in question or not. And we have this person here in front of us. So I'm thinking it's C. I'm just going to guess by the seat of my pants. Let's go with it. I'm locking in C.
Locking in C. So first, I'll start by eliminating questions.
Okay.
Answer D is incorrect because the character witness testimony is not categorically exempt from the rule against hearsay.
Yeah.
Answer B is incorrect because hearsay is not determined by whether the statement is relevant to the underlying cause of action.
Yeah, right? That one didn't feel
just
right.
not relevant.
Okay.
Answer C is incorrect because the fact that a witness is subject to additional examination about an out-of-court statement is not determinative of whether the statement is hearsay.
Okay.
Answer A is correct. The character witness's answer was not being offered to show that she was a licensed real estate agent. So we'll start with the definition of hearsay. Hearsay is an out-of-court statement used to prove the truth of the matter asserted. Basically, you heard something from someone.
Okay.
Because hearsay statement is not made under oath or in the presence of a fact finder or subject to cross-examination, it is seen as unreliable and presumptively inadmissible.
Okay.
An out-of-court statement may therefore be admitted if it is not offered for the truth of the matter asserted.
I see.
Here, if the character witnesses answer the question whether she told her neighbor that she was a licensed real estate agent was not being offered to prove that she was a licensed real estate agent, but rather she was being offered to prove that she had made the declaration. Therefore, it is not hearsay and is therefore admissible. The judge's overruling was valid.
Cool. Okay.
Yeah.
Wow. So specific. My goodness. How do lawyers remember all this stuff when they're on the floor?
These are all evidence questions we're doing today, and they're all easy ones.
Oh no!
So 79% of law students got your answer, got it correct.
No!
Answer C, your choice, was chosen by only 10% of respondents.
Hey, man.
D was chosen by 7, and B was chosen by 4.
Well, at least I wasn't 7 or 4.
Yes,
I'll take
exactly. So here, are you ready for your next question?
Yes. Oh my gosh. Straight into the next one. Let's do it.
A criminal defendant on trial for burglary had a prior misdemeanor conviction for making a false police report. Defense counsel did not want the defendant to testify because of the risk that the prosecution would try to impeach the defendant with prior conviction. May the prosecution impeach the defendant with the prior conviction?
Ooh, I don't know. What are my options?
A, yes, because the defendant may be impeached by any prior criminal conviction. B, yes, because it is a crime that relates to the defendant's character for truthfulness. C, no, because the conviction was a misdemeanor. And D, no, because the conviction's probative value is outweighed by its prejudicial effect.
Interesting. Okay. This is something that I don't know anything about, is the precedent of a previous criminal history that sets and how that can affect a new case. But I'm curious about the answer here. Would you please read me the options once more, please?
Sure. Here we go. A, because the defendant may be impeached by any prior criminal conviction. A, yes, because the defendant may be impeached by, apologies. B, yes, because it is a crime that relates to the defendant's character for truthfulness. C, no, because the conviction was a misdemeanor. D, no, because the conviction's probative value is outweighed by its prejudicial effect.
Okay, interesting. I'm going in a little blind again, folks, but I'm feeling B, that yes, because he has a prior history of lack of truthfulness. I'm not feeling strongly about it, but I'm thinking I might just lock in my answer as B.
You are absolutely correct.
Oh, yay!
Federal Rule of Evidence 609A2, crimes involving a witness's character for truthfulness must be admitted regardless of the type of crime, whether felony or misdemeanor, the type of witness, whether a criminal defendant or not, or how prejudicial the evidence is. Therefore, answer options C, A, and D are necessarily incorrect. Because it just categorically, it's basically just a cite to the rule.
Okay.
So when a crime involving a character for truthfulness involves the truthfulness of the matter, it must be admitted.
Beautiful. Well, folks, I'm at 50% so far. How popular was that answer?
76% of respondents answered B.
Sweet.
But the trap in this question was answer D, no, because the conviction's probative value is outweighed by its prejudicial effect. That is a thing, but that is not a thing here. So it was the trap laid by the question writers at Quimby.
My cluelessness saved me from the trap.
Yes. C, no, because the conviction was a misdemeanor. 9% of students answered. And yes, because the defendant may be impeached by prior criminal conviction. 2%. So pretty steep drop off. How you feeling so far?
I'm feeling all right. I'm 50-50. I'll take it.
Perfect. We're doing 3 today, so this is the last one. Are you ready for it?
Okay. Let's do it. This is the tiebreaker.
Okay, perfect. A defendant was on trial for drug trafficking. Go off, King. The prosecution sought to admit recordings of the defendant's drug transactions. On the recordings, the defendant used obscene and racist language in addition. Oh, maybe I shouldn't have.
Yeah, that's
maybe I
not a
really
go
should have
off.
read the whole thing before I pegged my name to that. On the recordings, the defendant used obscene and racist language in addition to admitting to several elements of drug trafficking charges. God, they caught this guy in 4K. The defendant objected to the recording's admission. Which of the following arguments best supports the defendant's position that recording should be excluded?
Interesting. What do we got?
Okay, I just want to make sure you had the prompt.
I'm curious.
A, the recordings have no probative value. B, the probative value of the recordings is outweighed by their prejudicial effect. I've heard that language before. C, the probative value of the recordings is substantially outweighed by the danger of unfair prejudice. And D, the probative value of the recordings is clearly and convincingly outweighed by the danger of unfair prejudice.
This is cool. I'm not sure where to start. I think I see possibility in multiple of those answers. And I'm really curious in the end whether or not these statements would be admissible. Can you please read me my answer options again?
Yeah, of course. The recordings have no probative value.
Okay.
The probative value of the recordings is outweighed by their prejudicial effect. C, the probative value of the recordings is substantially outweighed by the danger of their unfair prejudice. And D, the probative value of the recordings is clearly and convincingly outweighed by the danger of unfair prejudice.
All right. I'm feeling drawn towards C. I think that they suspect that the danger of his obscenities and racism would outweigh anything potential truthfulness brought with his admissions on the drug trafficking? I don't know.
Just want to make sure.
Yeah.
Do you mean to say the opposite? Do you mean the truth of the drug trafficking is outweighed by his racism?
Yes.
Okay, that's what C says. I just
Thank
wanted to
you.
say, make sure that I understood.
Got this flipped a little.
Are you locking in C?
Might as heckin' well. I'm locking in C.
That is correct.
Woohoo! 2 for
The
3.
probative value of the recordings is substantially outweighed by the danger of unfair prejudice. So this is a very, very long answer, but I'm going to try and condense it. So
Okay.
in general, evidence is admissible if it is relevant. However, Federal Rule of Evidence 403 permits a court to exclude relevant evidence if the probative value is substantially outweighed by the danger of unfair prejudice, confusing the issues, misleading the jury, wasting time, blah, blah, blah.
So if the jury had heard him being racist and obscene, then they would have had too difficult of a time not gaining prejudice towards him because of that.
Basically, that's sort of the defendant's defense's argument, because they're saying, like,
Yeah.
him being racist isn't really relevant to the question of whether or not you're a drug trafficker.
Yeah, that's true.
And so that would be their theory. They're like, this is too prejudicial. They're just not going to like him because they don't like him. And so judge, throw this out. However, the recordings are relevant because the defendant can be heard admitting to several elements of drug trafficking charges. That is relevant to the prosecution's case.
Yeah.
However, the court may exclude the recordings even though they are relevant if the defendant successfully argues that the recording's probative value is outweighed by the danger of unfair prejudice, obscenities, and racist language poses. Note that because the excluding, besides excluding the entire recordings, the court may choose to deal with potential prejudice in a different way. So, for example, the court may choose to admit the recordings, but prove the jury with a limited instruction that the fact that he's being racist should not enter into the deliberations whether the defendant is guilty of drug trafficking.
Yeah, disregard all of his xenophobia.
Yeah. And that was answered by 91% of respondents. Answer A, recordings have no probative value, was answered by 1% of students who presumably will go on to fail the bar. The probative value of the recordings is outweighed by the prejudicial effect, 6%. And D, the probative value of the recordings is clearly and convincingly outweighed by the danger of unfair prejudice, 2%. That clearly and convincingly language is, if you recall, there's only generally speaking, three standards in American jurisprudence. That's preponderance of the evidence, that's 51%. Clear and convincing, which is like a middle ground. I've heard it quantified around 70 to 85%. And then beyond a reasonable doubt, which cannot be quantified, that's the criminal standard. The question writers were just trying to confuse, adding an extra trigger language to get people to glom onto them. Well done.
Yay!
2 out of 3.
Not enough to pass the bar, but
yes.
You know what? That's okay. I'm not even trying to pass the bar.
The good news is 70 to 80% threshold is usually good enough in most jurisdictions. I'd have to look it up.
Sweet. Well, that's 66. I got to improve my numbers a little.
This has been Office Hours, brought to you by Quimby Bar Prep. Whether you need study aids, bar review, MPRE prep, or CLEs for continuing education, go to quimby.com. Thank you so much to the Quimby team for supplying our bank of answer questions. Lindsay,
seriously.
great work, and we will see you guys very soon.
Bye, everybody.